I'm Debbie Moraes, and this is Legal Matters, the program designed to address the critical issues facing businesses and consumers today. Legal information, practical solution, and straight talk on a wide variety of topics, from finance to family law, Social Security, workers' compensation, and more. In our last session, we discussed the rules of engagement, or the not-so-romantic side of broken engagements, as in what's left of that expensive ring, or the binding or not-so-binding contracts, who's responsible for what. I hope you were able to be with us. With us today, again, is our legal counsel from Odette Bizarre Cordero Grasso law firm in East Providence. We have Jackie Grasso and David Bizarre. Welcome again.
Hello. Thank you.
Today our topic is going to be criminal law, but as always we ask if you have questions about our last topic, and the last topic being about broken engagements and prenuptial agreements and such. The question is, are you ready? What happens, what is the time frame for holding yourself to be part of a common law marriage? We hear plenty about that. What's the story about common law marriage? Jackie, David?
In Rhode Island, there is no time frame for common law marriage. If you hold yourself out to be married to the public, and the public accepts you as being married, then you're married. It's not like adverse possession or some other types of things where you have to do something continuously for a certain period of time. A lot of times you hear people say, is it 7 years, is it 10 years? Frankly, it's one day if that's all it takes for the public to think you're married.
So honestly, does that mean if I sign my name as Mrs. Such and Such, and we were only engaged or promised or whatever, might I have to go through the things that you discussed last time about who has to pay for whatever? How does that
You'd
work?
Actually, potentially, if you're going to separate, have to go through
A
a divorce. There's a lot of different things you can do to hold yourself out to be married. Some of the more common ones are to file joint tax returns while you're living together, to have a family plan for medical insurance, and you add your spouse to the plan, even though you're not legally married. You hold yourself out as being married, and now there's been an acceptance by your employer or the insurance company to put them on the plan as being accepted as your spouse. If you do that, and the next day you decide you're not married anymore, the other person could argue, wait a minute, what's yours is mine and what's mine is mine, let's get divorced.
So you have to file a complaint for common law divorce, but the first thing you need to do is you need to prove that there's a common law marriage.
Right.
Because the person who's opposing distribution of the marital assets is certainly going to argue that we don't have a marriage, we're merely just cohabitants.
Common law marriage is really an evidentiary issue.
Yeah.
Is there evidence of a marriage, and what's the proof of it?
The other thing, just briefly, I want to point out, Rhode Island is one of the few states that does recognize common law marriages. Massachusetts does not recognize common law marriages. So if you lived in Massachusetts your entire life and held yourself out as husband and wife, never traveled to a state that recognized common law marriage, Massachusetts does not recognize it.
In which case, what would happen?
You're cohabitants. So we would maybe go to Superior Court and file a lawsuit for contractual purposes and dividing up assets. Much more difficult to do. But now, on the other hand, if you were in Massachusetts, you hold yourself out as common law husband and wife, you later move to Rhode Island. Rhode Island's a state that recognizes common law marriage. You stay in Rhode Island for a few years, then you decide to go back to Massachusetts, you want a divorce. Then one of the parties is going to argue, we're not married because Massachusetts doesn't recognize common law marriage. But it does if it's recognized in another state in which you represented that you were husband and wife.
That's a very important nuance.
It's a jurisdictional issue.
If you have a legal marriage in a particular state and then move from that state, there's a lot of case law that doesn't exactly follow this, but for the most part, if you have a legal marriage in one state, it's enforceable in another state if you move.
It's full faith and credit is basically what it's called, giving full faith and credit to the laws of the other state.
Throughout the U.S., are there many states that don't recognize or do?
I want to say the amount of states right now that recognize common law marriage are 16. I could be off by a couple, but my memory tells me 16 states still recognize common law marriage.
But don't ask us to name them.
No, we won't do that. I think it's time
Arizona's one of them.
Oh, okay.
Yeah.
That's good.
Besides Rhode Island.
Besides Rhode Island.
Okay, so a serious topic. Criminal law. We understand that there's civil law and there's criminal law. And I suppose that criminal law, somebody gets prosecuted. Civil law, somebody gets to sue. It's
Right.
among people, and it's not a prosecution. What's the difference? What's the...
You could have an activity
411.
that could result in both criminal action being taken and civil action being taken. For example, if somebody hits you, that's a criminal action of battery. But the person who got hit could also sue civilly for the battery, and the difference is civil law is designed to compensate the person for their damages. So if you were hit by someone, they broke your nose, you had hospital bills, you couldn't work, disfigurement, you can sue for money and be compensated with those damages from that person who hit you personally. The person who hit you also faces criminal prosecution for acting in a way society doesn't accept. It's not acceptable for people to go around and hit each other. And therefore there's a punishment for that. And criminal law is designed to punish.
What happens first? Is it generally that the criminal law case would be filed and then after or
Typically,
subsequent?
the individual's charged with a crime, whether it be misdemeanor, felony, depends on the type of crime it is. But typically what happens is they're charged with a crime, they're prosecuted through state or superior court, the state courts, and sometimes federal court. And then if the victim of the crime wants to sue civilly, he or she can do that. So it does happen, subsequent to the prosecution.
Not every case results in both a
That's right.
criminal case being prosecuted and a civil case being brought. It depends on the circumstances, the most famous of which would be O.J.
O.J.
Simpson.
Great
Everyone
minds
thinks-
think alike.
Right.
Yeah.
And it's harder to prosecute and have a conviction of a criminal case than it is a civil case?
You have a different standard. In criminal law, you have proof beyond a reasonable doubt. In civil, it's preponderance of the evidence. So,
Most.
Right.
yes, it's a lesser standard.
Right. The way that's explained in jury instructions
Mm-hmm.
sometimes is in a civil case, you take, the plaintiff bears the burden of proof, that's the person bringing the suit, and the judge might explain that a preponderance of the evidence means that if you take all the evidence and put it on a scale, the plaintiff has the burden of just tipping the scale. Whereas, of course, beyond a reasonable doubt isn't beyond all doubt, but you have to eliminate, other possibilities really from being possible, not possible, but likely.
And you also need unanimous decision in a criminal case.
Right.
But not.
It depends on
Case
what
is
state.
civil.
Civilly, in Rhode Island, we don't have 12 people on a jury, it's 6, and they do have to pretty much agree on the verdict, or it could be a hung jury.
Hung jury. Describe what constitutes criminal law, felonies, misdemeanors. What is what?
I can give you a good example. If I went like this to David, I've just committed a battery. But if I went like this to David, that's an assault. The difference is the battery is the touching. The assault is putting someone in fear of imminent harm. They're both a crime. They're both a crime.
I wasn't in fear. But
Yeah.
if I was.
That's what he says
and-
today.
And she was doing it to me in my capacity as an East Greenwich judge. The law says that a simple assault or simple battery of a person where there's not serious damage and they're not over 65 or in their official capacity is a misdemeanor. If it's somebody over 65 or in capacity as a police officer potentially or a judge or whatever, there could be a felony. The difference is what the length of time you would be looking at for a potential penalty. If it's more than a year in prison, it's a felony. If it's less than a year in prison, it's a misdemeanor, or a year or less.
And doesn't money usually factor in here too? If it's under a certain amount
Right.
that someone's likely to...
The
Correct.
bad checks.
Right.
Or,
The amount of the check
Yeah.
could factor in
Stolen
terms
property.
of felony versus misdemeanor, and the amount of the fine you face also factors as to whether that is a misdemeanor or a felony.
And what's the process of what happens to an individual if they're arrested from soup to nuts?
Depends on the type of crime you're looking at and who's investigating it. Let's take, for the sake of